Day 10 of the Sabarimala hearings continued today, and the other side presented its arguments. The 9-judge bench had some of its sharpest exchanges yet, this time with senior advocate Indira Jaising, who represents the two women who entered the temple in 2018, following the Supreme Court's judgment that struck down the ban on women aged between 10 and 50. Jaising's core argument was that individual religious freedom under Article 25 Clause 1 must prevail over the rights of religious denominations under Article 26. Courts, she said, cannot simply adopt a hands-off approach because judicial review is a constitutional power. Religions evolve, they are not static, and fundamental rights cannot be read in isolation. But the bench was not persuaded to let that argument stand unchallenged. Justice Nagratna drew a firm line. Article 25(2)(b, she noted, only empowers the state to legislate for social reform. It is not a right in itself. In the name of reform, don't hollow out the religion, she said. Let us not open rituals and ceremonies which are there for centuries. Justice Amanullah asked whether the two women were even devotees, whether someone who hadn't cared to visit the temple before the 2018 judgment could suddenly claim the right of entry. Jaising's answer was, the only requirement is reverence, not belief. I need to go with reverence or shraddha and not for the purpose of mischief. We go to the temples even though we don't completely follow the deity. Justice Nagratna asked directly whether custom prevails or one woman's desire. Jaising responded, it's not desire, it's a freedom. On the untouchability argument, Jaising shared a personal story. She told the bench that she grew up in a household where menstruating women were not allowed to touch others, not allowed to sit at the dining table, not allowed near funeral pyres. She said she knew what it felt like to be told that she was polluted, and that the purification ceremony conducted after the women entered the temple was an extension of exactly that logic. The exclusion of women on the basis of menstruation, she argued, is a form of untouchability prohibited under Article 17. Justice Nagratna also noted that the restriction need not be read as pollution in the sense of untouchability, and flagged a concern that if this reasoning were accepted, tomorrow someone would challenge the Hindu custom of avoiding temple visits after a birth or death in the family. And on the question of morality, Jaising argued that morality under Articles 25 and 26 cannot mean public morality, because public morality can be rooted in prejudice. What the Constitution demands, she said, is constitutional morality, and under that standard, individual rights cannot be subordinated to group rights. The hearings are ongoing, and LiveLaw has been covering these hearings extensively, so head over to livelaw.in for detailed reports of the last 9 days.